My name is Mike Foster, the Entrepreneur's Mentor, and welcome to my interview series, A Zoom With. Now, I regularly share my thoughts via my video snippets on my YouTube channel, but this is a series of interviews to introduce you to trusted experts with the view of them sharing their thoughts and their tips. And today I'm delighted to be joined by Vicki Strachan, the CEO of Strachan IP. Now, Vicki is a patent attorney with a difference. She has 20 years experience helping entrepreneurial companies to protect the parts of their business that keeps them ahead of their competitors. So welcome, Vicki.
Thanks, Mike. As you said, I am a patent attorney with a difference, and I'm the CEO of Strachan IP. Lots of business owners say to me that they don't have or need IP, but I always say where there's a USP, there's a reason that customers come to you, rather than your competitors. And there is almost always intellectual property, but it can only be made to work for and add value to your business if you know it's there and how to preserve it. So in a nutshell, we help innovative companies to protect their market share.
Fantastic. Thanks for the introduction. I guess part of the best way to ask you some questions is to take a scenario. So let's take a scenario that maybe I'm a founder of a thriving business that does product design and a manufacturing company that relies on innovation to continue to expand and improve its product lines and grow the business. So what difficulties in relation to IP have you heard of most often from these type of companies?
Yeah, often this type of company was started based on a first invention devised by the founder, who will usually be fully aware of the need to protect against copying and will have filed patent applications as part of the startup process. Each time there's a new innovation by way of improvement of existing products or complementary product lines, associated applications for registered IP rights they'll be filed, and the company quickly ends up with a sizable IP portfolio that's costing a not insignificant amount of money every year to maintain. As the company then continues to innovate and grow, the portfolio increases. Problems can arise because the CEO usually the CEO is usually still a now very super busy founder, and they become concerned about the escalating cost of IP within the business without really understanding where the value is and what each piece of IP brings to the table. Invoices and reminders arrive from their IP attorney, but without careful checking of references against their own records, they may not be fully aware of which piece of correspondence relates to which piece of IP. As a result, some obsolete IP rights could be unnecessarily maintained, whilst other possibly crucial IP rights may be abandoned because the CEO has become cross and possibly suspicious about the mounting costs.
So what could a business owner of this type be doing to address those problems that you mentioned?
Well, there's no great secret here. The first step is to properly review a rolling schedule or report of all their registered IP rights. They can ask their IP attorney for a schedule like that, and we provide them as a matter of course as part of our customer service. Then on the report, match each right to the product it relates to. And once you've done that, each time a cost point arises for an IP right, you can assess whether or not it's worthwhile to the business to maintain that right. This can be done simply by comparing the cost with the revenue generating performance of the associated product. But it's more worthwhile to ask yourself, what would be the damage to the business if a competitor were allowed to do what's currently protected by that IP right? So what could be the impact on your market share? That's one. But also, what damage could be done to your brand if cheap, low quality copies were to enter the market and be bought by people thinking they're yours?
Interesting. And like yourself, how could a trusted IP attorney help with these type of businesses?
We strive to work with rather than for our business owners. to make sure they have all the information they need at their fingertips to make the right commercial decisions for their business. We can act as advisors, but also a sounding board to help assess the commercial impact of securing, maintaining, or abandoning an IP right. We strive to be a key part of the business rather than traditional service providers, and we can often help to save business owners money, or at least help them to clearly understand the value they're paying for.
I just wanted to expand on a couple of points that we talked about prior to this discussion today, whereby, I think in the marketplace, there is potentially concern by businesses about escalating costs of their IP without actually understanding the value. Is that something that you see?
Yeah, it's a really common complaint of the type of business owner we've been talking about this morning. They very clearly understand the need for patents and registered designs and registered trademarks. But once it becomes a sizable portfolio and they get busier and busier trying to run a thriving, innovative business, which is constantly innovating, constant new products, new and improved products, it becomes very unwieldy. And their IP providers will send reminders and invoices, but without really sitting down and using references against IP rights and then matching them to their products, it's very difficult for them to work out whether or not it's worth maintaining the IP right. Often the IP rights all end up being maintained, even though some of them relate to obsolete technology, and others get dropped because the decision is that they're spending too much on IP and they need to cut back. But that then without a proper thought process in place.
I know from our conversations, one of the things that I love about what you offer is that you offer regular reviews of your clients' IP portfolios and provide a regular rolling schedules. Why is that so beneficial to your clients?
It's as beneficial to me as it is to the client. So by doing that, I can stay on top of not just what rights customers have or business owners have, but also the product lines, how those product lines are doing commercially, what the competitive landscape looks like, so that when the decision points come for each of these IP rights, I can offer a much more rounded advice and much more commercially focused advice than your traditional kind of transactional relationship.
Excellent. And I know you sort of talked before about making sure that the clients understand that they've got a renewal due, but is it worth still protecting that IP in consideration of the costs? Is that something that you're seeing more of your clients being sensitive to?
Yes, especially in the current climate, costs are key, and it's important not to be spending money where money shouldn't be spent, but equally ensuring that money is spent on key pieces of IP to ensure that, especially overseas competitors, borders have been obliterated during the pandemic with lots and lots of businesses turning to online selling and promotion. So it's become ever more important for innovative British companies to protect their innovation, because British product design is still seen worldwide as synonymous with quality. So we're not just talking about a competitor eating into a market share, but we're also talking about the real prospect of cheap substandard copies entering your market, people buying them thinking that they're yours, and then when they break, that damaging your brand.
And I guess my final question today is that IP covers so many different things, but I think too often businesses just think things like trademarks or copyrights, but I know in conversations we've talked about trade secrets before. So give us a bit of an expansive view of what people should be thinking about from their IP perspective.
Yeah, sure. So With a piece of technology, with a new piece of technology, people often think of patents. That's what protects technology. But there are a whole bunch of circumferential IP rights, for want of a better word, that sit around that technology, protecting particular elements of it. So to give you an example, going back to the innovative British company who started their business on the basis of one piece of innovation, and then they come up with a second piece of innovation and they file a patent application for that. But there are what isn't thought about is that they now have a database of customers, potential customers for their new innovation, that they built up selling their older innovation. And that database of customers may very well attract database rights, which is a sort of a copyright and a really valuable right when it comes to customer relationship management databases and contact databases. Then we might have there might have been some work that went into the integrated circuit that goes into the product. It might need to be carefully engineered so that it fits into a particular space. And then there are the obscure IP rights like semiconductor topography rights, which will stop somebody else from making an integrated circuit that's designed in the same way. And it could be crucial because it could be the one crucial element that stops them from making and selling what you sell because they can't make the integrated circuit in the same way. Know-how and trade secrets is massive, especially with innovative founders who have built their business on everything that they've put into the business, their know-how, their trade secrets. They've all been licensed to this company for however long it's been going, without anybody really knowing that for a long time at least, that's where the massive value lay.
Brilliant. Well, thank you, Vicki. Just to close this interview, then, just tell the listeners in terms of why you set up on your own business, because I love the story in terms of why you wanted to set up your own company rather than represent another corporate firm.
As I said, I specialize in working with innovative SMEs. It's always been my specialism and I love it. I like to work with them rather than for them to make sure that I become a key part of the business and I can really help and advise in commercial decisions. I have over 20 years experience all in sort of corporate law firms, but there's an inherent conflict of interest between the way I like to work with my clients and the duty and obligation to bill every second of my day. And that's why I set up Strachan IP, so that I can do business my way.
Fantastic. And I love that. I know certain people I know you've had conversation with, the value of the time that you've offered. If people want to find out a little bit more and have a conversation with you, how's the best way to contact you?
They can email me direct, vicky.strachan@strachanip.co.uk, or they can go to my website to the contact page and fill in a contact form and book a free initial consultation.
Super. Thank you, Vicki. Thank you for spending some time with me today and sharing your thoughts, experience and expertise with us. Much appreciated.
Thanks, Mike.
So please do subscribe to my YouTube channel and get notified each time I publish a new interview. And I'll see you next time for a Zoom with whoever's next.